Hi, everybody. Welcome to Chapter 5, which is going to focus on victims' rights. So, one of the first rights that victims have is the right to notification. And victims have the right to notification of the proceedings that are going to happen throughout the criminal justice process. So, for example, they have the right to know if the victim is, or excuse me, if the offender is being released on bail, if the offender is going to be tried in court, if so, on what date is that going to occur, if they're incarcerated, what is the release date. They also have the right to notification of, if they're up for parole. Victims have the right to be notified of all of these processes so that they're aware of what's happening regarding the case that they are at the center of. Typically, the people who are responsible for these notifications are going to be prosecutors, law enforcement, and corrections officers are all going to be responsible to provide notification to the victims. And again, it allows the victim to stay apprised of what's happening from start to finish, from the point of the involvement of the criminal justice system in their victimization. As time goes by, it's just sort of reflective of the times. More notifications are being done by technology, messages via text message, messages via email that are generated automatically at each stage through the system. In part because it's cheaper, but also it takes away the option for human error where people were forgetting to contact victims and therefore their rights are being violated. Participation and consultation are other areas that victims have access to. And the goal here is to provide the victims with the rights that they have so that they can be involved in the prosecution and the knowledge of the prosecution and the CJ process. And it allows them to have a voice throughout the proceedings. Historically speaking, victims have always just been treated as evidence that, your testimony of what happened, give that to us. We'll take it from here. You're sort of an afterthought on the sidelines. And part of the victims' rights movement was like, wait a minute, there would be no proceedings without the victim. So shouldn't the victim have a central role in at least knowing what's happening? And shouldn't the victim be involved in every stage of the proceeding so that they don't lose their voice and so that we as the criminal justice system don't lose sight of the fact that the victim is why we're all here, right? That why we're all here. And that's why we don't want to lose the victim in the process. How do victims participate in the process? Well, one of the most noteworthy ways that they can do so is through victim impact statements, which are statements that are read to the offender in the court hearing prior to sentencing. This is something that's relatively new within the last 25 years of criminal justice. Prior to victim impact statements, there was no ability for the victim to speak at all unless they testified. And even in the role of testimony, they were only allowed to answer the direct questions in which they were asked. They never got to speak to the offender or to speak to the court to say, this is how this victimization process impacted me. This is how it's changed my life. This is how it's hurt me. They've never had the ability to have their say and to communicate the harm that truly was done beyond being, air quotes, that piece of evidence. Victim impact statements allow this. They get to write an entire statement that they get to deliver to the judge, to the offender, in front of prosecutor, defense attorneys, and everybody in the gallery and say, here's what happened to me. Here's how I feel about it. Here's what's still happening, how I'm still suffering as a result. Not only does it give them agency and it gives them a catharsis, it gives them a voice in the process, but it's a part of the healing process for them. In addition, it also influences how the sentence is ruled upon. Guilt has already been determined. This gives the victim the ability to look at the judge who is determining sentence and say, Judge, let me tell you how I feel. Let me tell you what I'm still suffering before you make this decision. I want to make sure you're fully informed on my role and what's happening to me before you hand down this decision, right? So it gives them agency in the process, gives them input. They also get to provide input to prosecutors along the way on aspects of plea bargaining conditions. Remember that 97% of all cases that are prosecuted are plea bargained out. Only 3% of cases make it into an actual courtroom, which means the vast majority of victimizations are going to be handled with plea bargains. For a very long time, victims had no role in this. It was and it still is, solely at the discretion of the prosecutor what plea bargain they want to offer the offender in exchange for a guilty plea. However, there is now a shift in the way in which this is done, where prosecutors will sit down with the victims and say, Here's what I'm thinking of offering. Tell me your response to this. Do you think this is adequate based on what you've suffered? Or if it's inadequate, tell me why you think this is inadequate and give me your input. It's still the prosecutor's call, but at least we're dialoguing with the victim and we're letting them have a role in this decision making. Excuse me. There's also the right to protection for the victim. So participation in the prosecution on the part of the victim can put the victim at risk in a multitude of ways. Obviously, the victim is the primary evidence in most cases. They're the primary witness. They are very likely to have to give testimony on the stand, to be questioned by the prosecutor, to be questioned by the defense attorney. Even if they never make it to the stand, they certainly have to go through an investigatory process where they're going to be questioned repeatedly by police, by prosecutors, etc. And the right to protection is instituted to protect victims from retaliation so that they are not in harm's way for participating in this process and providing the evidence that is necessary to prosecute the individual who has provoked their victimization. So they should have protection from the offender, from the offender's family and friends, from retaliation that can come from any of those groups. Throughout the process, so that there's no threat of harm and that there's no actual harm through the process that A, keeps them from participating and prosecuting their offender, but B, also just so there's not, again, another instance of victimization. They may be given no contact orders against the assailant during the process, meaning that the assailant cannot come within a certain geographic range of the individual. The assailant cannot contact them by phone, by text, by email, limiting those contacts, and that if that no contact violation is or stipulation is violated, that the individual will be immediately arrested upon violating that. Victims are often provided separate waiting rooms so that when it is time to provide testimony, they don't have to sit and be stared at or be in the presence of the offender, the offender's friends, the offender's family, where they can be intimidated, where they can be commented at or upon, or where they even just have to sit and share the same space with the person who violated them in the first place. So that right to protection is huge. There's also the right to their personal information being protected so that their details are not to be made public. Right? They have the right to say, I didn't choose to come to court today. I was brought here because I'm a victim. And I don't want my address, my email, my phone number. I don't want these things made public so people can dox me online or so people can contact me with threats or with harassing comments and emails and phone calls, which would just be yet again more victimization. I'm here to protect myself. I should be protected. I'm here to keep my offender from offending against other people. My personal information should be protected. So they have that right to protection. Just like the accused, the victim also has a right to a speedy trial. Victims have a voice in some jurisdictions about whether or not the trial can be postponed. Victims may want to expedite a trial for certain reasons, specifically with elderly populations. Disabled populations or minor victims, we want to expedite. We don't want to drag out the court process. Court processes are stressful. They're timely. People have to take off of work. People have to take off of school, etc. So the victims, turning their lives upside down to be able to pursue their offender through the legal system. They should have a right that if this is the fifth postponement, that they say, you know what, we've had enough postponements. I can't keep doing this. I can't keep doing this emotionally. I can't keep taking off of work. No more postponements, right? Or in the case of an elderly person, I mean, we gotta focus on pragmatic issues. They're not gonna live forever, and if we drag this trial out over 2 years with postponements, the victim may no longer be here to testify, etc., or to see their day of justice. So how about we expedite? Same thing with minor children. We don't want to drag this out with small children. They were already victimized. We don't want to traumatize them by having them coming in and out of court for 2 years, etc. So they have a right to a speedy trial. Victims also have evidence rights. So there are a couple things that fall under evidence rights. So first and foremost, one of the things that really brought this to the forefront was that when an individual is raped, they have to, part of the evidence collection process is going to the hospital and having a rape kit conducted. A rape kit is already a re-traumatization for a victim of sexual trauma, sexual rape, and so forth. They have to have vaginal swabs taken, anal swabs taken. They have to sit naked in front of strangers, having evidence collected off of their bodies, photographs taken. It's already a dehumanizing experience that somebody who was just sexually assaulted doesn't want to have to go through. And to make matters worse, the medical system used to make them pay for their rape kits, which couldn't be more insult to injury. And so evidence laws were instituted saying, hey, this is evidence collection. The victim should not have to foot the bill for this in order to move forward, for the prosecution to be able to move forward to prosecute their offender. So evidence protections and evidence rights came in saying victims no longer have to pay for their rape kits. In addition, individual private items are often collected when somebody's victimized as a part of the evidentiary collection. So clothing, jewelry, personal effects that were present during the victimization that may have bodily fluids or some sort of evidentiary value are collected and taken into custody throughout the process. Many victims would never receive those items back. And, some of those items, especially jewelry items, maybe family heirlooms, whatever, are of great emotional significance to these individuals. And even if they're not, it doesn't matter. It's their stuff, right? They should get it back. And they weren't getting their personal effects back after the trials were concluded. So this was also introduced to evidentiary rights that, yeah, whatever's theirs after the trial's done, after it's been entered into evidence, that needs to go back to the victims. They need that, those materials need to be relinquished to them. Some states have taken issues with the introduction of victims' rights as states want to be the sole focus of the harm caused by the perpetrator. And this is, sort of antithetical to the victims' rights movements that remember that, yes, the state is prosecuting this. The state is incurring the charges, but there would be no crime to prosecute. There would be no case to have had without the victim. And remember, the real harm happened to the victim. So the victims' rights movement is very unhappy with states that battle or give pushback on these victims' rights. And of course, there's always been instituted where there are these rights on the books in certain states, but they are not respected. They are on the books. It's been legislated. You're supposed to do it. But in practice, these rights aren't extended to victims. And when that happens, unfortunately, there's typically very little that the victim can do in recourse beyond verbally complain. It's still a work in progress. So let's talk about the the Victims Crime Act of 1984. We already introduced this in a previous chapter. Established that federal agency that provides funding to state agencies to support people victimized by crime, to reimburse money lost to medical bills, therapy, lost work, harm, etc. There's also other legislation that has been enacted since this introduction that is there to support victims and act on behalf of victims. So the Child Bill of Rights of 1990 extended a Victims Bill of Rights to children. It made provisions for proceedings. And most importantly, it made provisions that these proceedings be explained to children in a language that they can understand. Remember that court processes are incredibly detailed. There's a lot of legalese. There's a lot of legal jargon being thrown around that most adults don't know. Certainly, a child victim is not going to understand the proceedings. And given that they are the center and the focus of the entire pursuit of justice, they should be told what's going on in a way that they can understand. So that's what the Child Bill of Rights of 1990 did. We also have the Victims Restitution Act of 1990, and that provided a bill of victims' right to restitution for all federal crimes. So anytime a victim falls victim of a violation of federal law, they are owed restitution as a result. That is guaranteed by federal law now. That if you've been victimized by a federal violation, you are owed money. You are owed restitution to make you whole for that victimization. The Violence Against Women Act of 2013 provided provisions and funding for rape prevention, rape education. It also provided funding for battered women's shelters and transitional housing, as domestic violence is a very common crime against women, and there's always been a big sort of gap in how we handle it. That, when a woman is married to her abuser or cohabits with her abuser, where does she go to be physically safe from harm? That was sort of the bottleneck in our pursuit is, they can't just up and buy a new house. They don't have the money to. They don't have the money in many cases to just go get a new apartment. So this Violence Against Women Act provided those funds to create shelters so that they have some place to stay and physically leave to maintain their safety, and also to provide for transitional housing for victims of domestic violence. So they have a place to stay while they're getting their feet underneath of them, while they're getting money together to get an apartment, that they have a place where they don't have to pay, but they can stay there for a month or two while they get their belongings out of the house, while they figure out where they're going to live in a place where they can afford, while they save up some money to be able to move out. So there was a nice, there are these dribs and drabs of legislation that are being handed down over time that benefit victims of crime. We talked about victim compensation programs. They're present in all states. These are, in some parts, there are fines and fees paid by the assailant, and some of those fines and fees go to restitution and compensation to the victims. In addition, it is supplemented by federal monies. If we only relied on monies paid by fines and fees, there are a ton of offenders out there that can't afford to pay fines and fees, which means that compensation would never make its way back to victims. So this has to be subsidized by federal funds to make sure that victims are made whole. This money can be used for all sorts of things. It can be used to offset mental health counseling costs to victims, medical bills. It can be used to fund funerals in the cases of homicide. However, it is typically, the target number is that it's usually capped at around $25,000 per victim, per state, per offense. There is criteria. States don't just hand out that $25,000 willy-nilly. Criteria must be met. The first criteria is that those crimes must be reported to the police in a timely manner. You can't wait 10 years to report a crime to police and then apply for this money and expect to receive it. The victim must also cooperate in law enforcement investigation and prosecution of the offender. So you can't come to law enforcement and say, I want to report a crime, and then they go arrest the person, and then you say, I want victims compensation, but I'm not going to testify, and I'm not going to go on record. So you have to be an active participant in minimizing future victimization by prosecuting the individual who victimized you. There has to be evidence of the cost that you incurred. So you can't just show up and say, hey, I need $25,000. You have to come with receipts from the hospital saying this is what I had to pay, to fix my broken leg, to whatever. My house was destroyed. These are the costs that I incurred. Here are the receipts. You also have to provide evidence that you have gone through insurance outlets first before pursuing victims' compensation. So if you have physical damage, you have to say, here's what I went through insurance, here's what they covered, here's what they didn't, right? And what they didn't is what the victim's compensation will cover. But you have to go through that first. You can't say, I want my $25,000 and I'm going to go through insurance who's going to cover the bulk of it anyway and then just pocket the cash. This is there to literally help people who have had harm or who need an escape plan from chronic domestic violence, for people to fund funerals in the cases of homicides, etc. So there are limitations on it. And the final limitation is that you as the victim can't engage in criminality. If you break the law, even if you break the law relative to your victimization, if you break the law, you're not eligible for these funds. Okay, because the point is that we're trying to help victims, but we also don't want to encourage victimization in any capacity. So there are limits on that money. Restitution, I just want to get a definition out there as well. And these are monies that are going to be paid directly from the offender to the victim, like we said, to cover medical bills, stolen or damaged property, etc. And this is in addition to victims' compensation. So this is on top of victims' compensation. Another option is also civil litigation, and this is where victims can pursue additional monies in civil court. They can also pursue money for pain and suffering, which you can only pursue money and compensation for pain and suffering in civil court, where you actually sue your offender and you say, here's all the things that I incurred as a result of my victimization. And by the way, I have PTSD. I have anxiety. And by the way, you broke my hip when you threw me down the stairs, and I had to be on painkillers for 12 months, and I still have pain, and I expect to be compensated for that. And if you win your civil litigation, you will win compensation. That is, of course, if your offender has compensation to pay. Most offenders, many offenders, if they have it, if you have assets, if you have a bank account, they're going to garnish your bank account. If you own real estate, they're going to, garnish, they're going to put a lien on your house, and that money's going to go to the victim. But in many cases, because crime is driven in so many populations of poor people, there's no money to be had. So even if you win your civil litigation, you're not going to ever see a dime from that settlement, which is why things like restitution and victims' compensation are super duper important, because even though you have the right to win or to pursue civil litigation, even if you've got a no lose case, it doesn't mean that your offender has the ability to pay you out for the settlement that they owe. We also have victims witness assistance programs. This is a very fertile area for employment, by the way, victims assistance. And these are individuals who work in the criminal justice program, and they are assigned to victims. So literally a victim comes in, a case is started by prosecution, and a victim's assistant or a victim's witness assistant, depends on where you work as to what they call it, is going to be assigned to you to explain to you the proceedings, to walk you through the process. When you have court, they're going to go to court with you. They're the ones who are going to, do the logistics of getting you the special waiting room that is in isolation away from the offender and the offender's family. They're going to do all of that legwork to make sure that your rights are being respected under your state's Victims Bill of Rights, to make sure you know what's going on and to make sure that your needs are met throughout the process. There's also restorative justice in victims. There has been a shift towards a restorative justice paradigm in the criminal justice system in recent decades. Excuse me. This deviates from the traditional adversarial process that we typically see in the court systems, where it's prosecutor against defense attorney and it's an all-out fight to see who can win the case. Restorative justice is a different approach that says, let's not go down that road. Let's do something else. Let's bring the victim in the room. Let's bring the offender in the room. Let's have a mediator, and let's have a dialogue between the two, and let's have the offender listen to the damage that they caused the victim, and let's have the victim be able to ask the offender questions like, why did you do this to me? Do you understand what this did to me? So I want you to speak to the damage that I just explained to you that I'm suffering. How does it make you feel? Do you even care? Right? And that it is literally a mediation process of accountability meant to hold people accountable. Again, this approach is meant to put the victim back in the driver's seat, back in the center of the process, not on the periphery as a piece of evidence, but in the driver's seat as an active participant in the case that is being pursued against their victimization. There are mediators that will be present to keep it appropriate, to keep it safe, to keep it controlled, so it doesn't turn into a brawl, so it doesn't turn into just, a freak out moment for everybody. And the whole point here is to communicate the harm of the victim to the offender. And then after all of that communication is done, to say, okay, now that, we've established what's happened and what the negative effects are of that victimization, what would make it better? Let's figure out what would fill the hole that's been left here. And let's create a plan. And victim, if you agree to this plan, and offender, you're willing to put forth this plan, this is how you can avoid prison time. But everybody has to agree. Everybody has to agree. And the victim has a central role in that decision making. There's also victim impact panels. This is sort of an interesting thing that was introduced by Mothers Against Drunk Driving. You may know it as MADD, M-A-D-D, all capitals, where offenders have to sit in front of a panel of, in the case of MADD, it was in front of a panel of mothers whose children had been killed to drunk driving. And those offenders were people who either killed their children or just generally people who had been arrested for DUIs, driving under the influence, would have to sit and look these mothers in the eye, and these mothers would say, let me tell you how a drunk driver killed my son or killed my daughter, and let me tell you how my kid died, and let me tell you what it did to my life. Now you tell me why you think it's okay to drive drunk and put everyone else at risk. Right? That has expanded beyond Mothers Against Drunk Driving into other forms of victimization, where the victims will show up and say, let me tell you what you've done to me. Now you tell me why you think it's okay for you to do this to me and other people. Right? And again, it's a measure of accountability. And what we have actually seen is that people who go through, offenders that go through these victim impact panels, have decreases in their recidivism rates, which means the victim impact panels are working. Right? It is holding them behaviorally accountable. They don't like having to look their victims in the eye. They don't have an explanation. They do feel guilt. They do feel culpability. They are internalizing and understanding the harm and the damage that they have caused, and it's keeping them from offending again. Not all of them, right? But out of 100% of the offenders who go through victim impact panels, we see that they are less likely to reoffend. So it's having a positive impact, not only for the individual victim that is there engaging and dialoguing with their offender, but it's keeping them from creating victims in the future as well.